versus Raul Valle. I'd ask counsel to please identify themselves for the record.
Good afternoon, Your Honor. Mark Durso for the State of Connecticut.
Good afternoon, Your Honor. Tatiana Messina for the State of Connecticut.
Good afternoon, Your Honor. Kevin Smith for the defendant, Raul Valle, is at my side.
All right, so counsel, as you are aware, we have received a note from the jury which indicates that the jury has reached a partial verdict. And when I say partial verdict, in summarizing the note, which does indicate to some extent the deliberative process, it appears that the jury has reached a verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at both counts 2 and 3, and assault in the second degree intentional at count 4. At this time, the court's intention would be to accept the partial verdict and declare a mistrial on any lesser included charges upon which the jury is unable to reach a verdict. I will note that the note additionally indicates that after lengthy deliberations, the jury is hopelessly deadlocked on the other charges. So I would give each counsel an opportunity to be heard at this time. I'll stop.
Thank you, Your Honor. The State would be requesting that the court now at this moment give a Chip Smith charge to the jury. They've been out 2.5 days now, I guess, a little over 11 or 12 hours. There were 25 witnesses that were called in this case. There was a mountain of evidence that needed to be reviewed. And we went from hopelessly deadlocked after an hour and 45 minutes to now having a partial verdict. So I would submit that perhaps there'd be, if the court was inclined to give that Chip Smith charge, that they could go back and maybe come to a decision on the charges for which they are deadlocked on.
Thank you, Your Honor. Your Honor, the defense would object to a Chip Smith at this point. The court has already twice sent them back with essentially a Chip Smith light sort of instruction on the basis of Feliciano. And I think that the jury has indicated now on a number of occasions that they are rather hopelessly deadlocked as to those charges which they still cannot come to any resolution on. My understanding of the note is simply that giving them another charge is not going to change that, and so we would object.
So in response to the request for the Chip Smith, which is basically another attempt at the court to ask the jury to continue its deliberations, the court is hereby denying that request on behalf of the state. In keeping with Feliciano, this court has not once but on 2 occasions provided a chunkier or a wider Feliciano charge. On day 1 of the jury having this case, the court received a note that it was hopelessly deadlocked on the murder count. The court, upon agreement with counsel at that point in time, instructed the jury to continue deliberating. At that time, I instructed the jury to review the evidence, discuss and consider the opinions of other jurors, to explain the views and listen to the views of other jurors, including the majority, to listen to what the minority had to say, as well as the minority to listen to what the majority had to say. Subsequently, on day 2, after about 5 hours of continued deliberations having passed, the jury did send a second note indicating the following: that the jury was deadlocked on murder at count 1, indicating that the jury had reached a verdict at count 2 and count 3 as to assault in the first degree, deadlocked as to lesser included charges, and with respect to the last count, count 4, again indicating a possible verdict as to assault in the second degree, intentional, but deadlocked as to the first lesser included charge as well. Once again, that note was discussed with counsel. Once again, upon agreement by counsel, the court extended to the jury another Feliciano type charge which included more language than the standard go back and deliberate charge. The court once again looked at the jury and instructed the jury to continue deliberating, to review the evidence, see if any evidence was overlooked, make sure that no evidence was misunderstood, and to explain the views and listen to the views of all other jurors. The jurors did continue their deliberations, and they did review some evidence, which we came back on the record to produce for them. So at this point in time, the court is not going to go ahead and give them a third instruction to continue the deliberations. The court is going to accept the verdict.
And just one more thing, if I may put on the record, Your Honor, with regards to the court's intent on declaring a mistrial on the remaining charges that do exist, the state's intent would be, if that were the case, that we would be filing an amended information to include those charges.
All right. Well, I don't know when you would be filing that amended information, but we're going to accept the verdict before any amended information is filed.
Thank you.
Nothing, Your Honor. Thank you.
We have a verdict. We're going to take that verdict. Does anyone else have anything else to say?
Nothing from the state, Your Honor.
Not from the defense.
All right. At this point, we'll bring the jury in, please.
Sir? The rest of the jury. Oh, you're not.
All right. It appears as though all of our juror members are present. I would seek the counsel's stipulation as such before I begin.
The state will stipulate to the presence of the jury, Your Honor.
Defense stipulates, Your Honor.
So I first like to inquire as to the foreperson. The foreperson, please just stand. Thank you. All right. So, Mr. Foreperson, I did receive the note that was signed by you, and it was time-stamped as well. The note indicates to the court that the jury, although unable to unanimously agree on some charges, has unanimously agreed as to a verdict on murder at count 1 and manslaughter in the first degree intentional at count 1. Also, as to counts 2 and 3, the jury has a verdict on assault in the first degree intentional. And then lastly, as to count 4, the jury has reached a verdict as to assault in the second degree intentional. Is that correct?
Yes, Your Honor.
All right. So at this point in time, I would ask you to be seated. All right, the court at this point in time is going to move forward with the verdict that you do have relative to the counts and the charges that you have relayed in the note and that you have just confirmed on the record. So Madam Clerk is going to be providing to you additional instruction as she accepts that partial verdict, okay? Thank you. Come on.
Ladies and gentlemen of the jury, as your names are called, please indicate your presence by answering here, rise, and remain standing. Identify himself for the record.
Yes, here. James Stone.
Thank you.
All but the foreperson may be seated. Mr. Foreperson, in the case of State of Connecticut versus Raul Valle, has the jury agreed upon a unanimous verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at counts 2 and 3, and assault in the second degree intentional at count 4?
Yes, we have.
Will the defendant, Raul Valle, please rise and face the jury? Do you find the defendant guilty or not guilty?
Not guilty.
I'm sorry, hold on a moment. We have to go through the in docket number 8.
Oh, it's not on here. Sorry. In docket number AAN CR 22-0189-418T, count 1 of the substitute information charges the defendant, Raul Valle, with the crime of murder in violation of section 53A-54A paren A of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55 paren A paren 1 of the Connecticut General Statutes, do you find the defendant guilty or not guilty?
Not guilty.
Okay, Madam Clerk, please pause. All right, I'm going to direct the court's inquiry to the foreperson at this time. Mr. Foreperson, your note indicated, and that's Exhibit 10, Court Exhibit 10, your note indicated that the jury, after lengthy deliberations, was hopelessly deadlocked on manslaughter in the first degree reckless in violation of Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1. Is that correct?
Yes, Your Honor.
All right, so you were unable to reach a unanimous verdict as to that particular charge, is that correct?
That's correct.
Madam Clerk, please continue on with count 2.
Count 2 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59 paren A paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, again, the note that was sent to the court, provided to the court and marked, indicates to the court that after lengthy deliberations, the jury is hopelessly deadlocked on the charge of assault in the first degree reckless in violation of 53A-59A3 as a lesser included offense at count 2. Is that correct?
That's correct.
All right, so you were unable to reach a unanimous verdict regarding that particular charge as a lesser included offense. That is correct.
That's correct, Your Honor.
Thank you. Madam Clerk, please continue on to count 3.
Count 3 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59 paren A paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Again, Mr. Foreperson, Exhibit 10, Court Exhibit 10, your note to the court indicates that with respect to assault in the first degree reckless under count 3, after lengthy deliberations, the jury is hopelessly deadlocked on that charge of a lesser included offense. Is that correct?
Yes, it is.
So you were unable to reach a unanimous decision as to assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 as a lesser included offense under count 3. Is that correct?
Yes, Your Honor.
Thank you. Madam Clerk, please proceed to count 4.
Count 4 of the substitute information charges the defendant with the crime of assault in the second degree intentional in violation of section 53A-60 paren A paren 2 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, the note that was forwarded to the court indicates that at count 4, as to assault in the second degree reckless, after lengthy deliberations, the jury was hopelessly deadlocked on the above charge. Is that correct?
That's correct.
All right, so is it correct that the jury was unable to reach a unanimous decision as to assault with second degree reckless in violation of Connecticut General Statutes, Section 53A-60A3 at count 4.
Yes, Your Honor.
Thank you. One third and third proceed.
Your Honor, may the verdict be accepted and recorded?
Yes, the verdict shall be accepted and reported.
Ladies and gentlemen of the jury, listen to your verdict as it is accepted and recorded. As to the first count of the substitute information charging the defendant with the crime of murder in violation of Section 53A-54A of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of Section 53A-55 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the second count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of Section 53A-59 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the third count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of Section 53A-59 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the fourth count of the substitute information charging the defendant with the crime of assault in the second degree intentional in violation of Section 53A-60 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
Ladies and gentlemen of the jury, please rise. You heard your verdict as it was accepted and recorded. You heard your verdict being read back as to each of the 4 counts. Is that your verdict? So say you all. Yes. Thank you. You may be seated. Anything from counsel at this point?
No, Your Honor.
No, Your Honor, may we be seated?
I'm sorry?
May we be seated?
Yes, you may be seated. Thank you. I, on no request by counsel, the court is not going to hold the jury, so I won't have anything. All right, ladies and gentlemen of the jury, I'd like to address you. Take a moment. Your verdict has now been recorded. It's been accepted by the court. The court will deal with the outstanding remaining charges once I discharge you, but I want to say a few words to you before I do that. Your oath that you've been obligated to keep during this time, you've been obligated to stay silent, not discuss this case. I am now relieving you of the duty of your oath, so you are released from your oath. It is, of course, up to you to decide whether or not you wish to discuss this case with anyone or your role as a juror with anyone. You certainly have no obligation to do so, and please be aware that any comments that you shall make may become the pause for further proceedings concerning the verdict. I would like to take this time to recognize you and thank you for your very important service, serving as a juror, especially on a lengthy trial such as this. This takes you away from very important other aspects of your life. So I want to thank you for the time commitment that you gave to this case. I know that we originally asked you for a commitment through July 1st, and you have graciously given us your time for a rather extended period beyond that July 1st date. Inevitably, a decision by a jury will gratify one party and disappoint another. It's a very difficult job that you have. It's a difficult job for a juror to be asked to make a decision, such as important ones like this. And I understand, and so does everyone involved, that the decision that you made here today is not an easy one. These are decisions, however, that are extremely important to our society, as well as the individual defendant. We all recognize that it's not an easy one, and we thank you for taking the time to reach the decision that you did reach here today. We're very grateful to you for performing that very important assignment. I want to also thank you for your careful and diligent attention to these proceedings. I know that sometimes it's very difficult to get through evidence. It's not always as exciting as it's portrayed on TV or in the news. You as jurors have to stay alert and awake and dedicated to every moment of evidence that's presented before you. And I constantly remained vigilant of all of you and your attention, and I want to thank you for providing us the attention that you did. So at this point, I want to let you know that you are discharged again from your oath. You are allowed to leave. However, there are documents that we do need to provide to you, and I would also like an opportunity with you to give you those documents with the clerk. I would appreciate it if you would stay back here at the courthouse for a little bit. There are some matters I do need to tend to on the record, but if you would just give us a little bit more of your time just so that I can get you those documents, I would appreciate it, although you are under no obligation to do that. So that's an individual choice. You will be escorted out by the marshal. I will ask that you remain in the room for a little while so we can clear halls and I can clear the courtroom and then hopefully get a chance to speak with you. Thank you. Attorney Smith, at the end of evidence, at the close of evidence, you moved for a judgment of acquittal on the 4 charged offenses, paying most attention to the murder charge at count 1. The defendant has since been acquitted as to all of those charged offenses in the substitute information. What is your position relative to the motion for judgment of acquittal on those 4 offenses?
Withdrawn, Your Honor.
So the court's noting that for the record. With respect to count 1, manslaughter in the first degree reckless, Connecticut General Statutes, Section 53A, 55A3, count 2 and 3, assault in the first degree reckless, Connecticut General Statutes, Section 53A, 59A3, and count 4, assault in the second degree reckless, Connecticut General Statutes, Section 60A3. After the jury's inability to reach a unanimous verdict, the court would like to memorialize on the record the following. On day 1 of the jury having the case, after about 2 hours of deliberations, the jury sent a note stating that it was hopelessly deadlocked on the murder at count 1. The court, upon agreement of counsel, instructed the jury to continue deliberating, instructing the jury to review the evidence, discuss and consider the opinions of other jurors, to explain views and listen to the views of others, including the majority, to listen to what the minority had to say, and the minority to listen to what the majority had to say. Subsequently, after a total of about 5 hours of deliberations having passed, the jury sent a second note to the court indicating that the jury was deadlocked on murder at count 1, not guilty of first-degree assault intentional, deadlocked on first-degree assault reckless at count 2, with the same indication for count 3 on the same charges, and not guilty second-degree assault intentional, deadlocked second-degree assault reckless at count 4. Once again, upon agreement of counsel, the note was disclosed to counsel. Obviously, it was reviewed, it was discussed, and I directed jurors to continue deliberating, instructing the jurors to review the evidence, see if any evidence was overlooked or misunderstood, to explain the views and listen to the views of all other jurors. The jury continued their deliberations into the 3rd day. And now, once again, on this 3rd day, after more than 11 and a half hours of deliberations, the court received a note from the jury, now Court Exhibit 10, indicating a partial verdict, and that as to the other charges, the lesser included offenses, that after lengthy deliberations, the jury was hopelessly deadlocked. Due to the jury's inability to reach a unanimous verdict, even after extended deliberations, as to manslaughter in the first degree reckless, Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3 as a lesser included offense at counts 2 and 3, and assault in the second degree reckless, Connecticut General Statutes, Section 53A, 60A3. The court, in accordance with the Connecticut Practice Book, Section 4245, and with no objection by counsel. Counsel, do either of you want to object? I know before you indicated you didn't. Objecting to a mistrial?
No.
No, Your Honor.
All right. Hereby finds it necessary to declare a mistrial as to those offenses and all other lesser included offenses charged to the jury under counts 2 and 3, to which a verdict was not returned. The court does not take the ordering of a mistrial lightly. The court is not ordering a mistrial simply for the sake of ordering a mistrial as a matter of convenience. Rather, the court, based on the history of deliberations as cited herein and the notes provided by the jury, finds that the circumstances make it impossible at this point to reach a verdict fairly as to all parties, and as such, with a finding of manifest necessity in accordance with our rules, does enter the order of the mistrial. I'd also like to take a moment to address everyone. I first would like to address counsel and thank them for their courtesies to the court and to each other during the course of this trial. Also to the family members, all of them, the spectators that have been present in this courtroom every single day. I want to thank you for heeding the court's expectations as to courtroom decorum. I know that this was an extremely emotional trial, and I appreciate the conduct that was displayed continuously throughout this process. Once again, I understand that a jury's verdict will never fully satisfy one side or the other. Not everyone will walk out of here satisfied today. And I apologize for that, but this is the process that we have, and the court believes it to be a fair process. I also want to indicate that my appreciation to courtroom decorum extends to every single member of the media. I think you've portrayed this matter as fairly as possible in the news, and I think that your courtroom decorum here in following all the rules that were placed on the media by way of court order have been met with professionalism in terms of your business and your duty to your job. So I want to thank you for that. At this time, I'd ask counsel if there are any other matters that the court should take up.
Nothing from the state at this time, Your Honor.
Not from the defense, Your Honor.
Lastly, I would like to address Mr. Valle. Mr. Valle, you too have shown respect to the process in terms of your decorum and your behavior and conduct here in the courtroom. You have been acquitted of the 4 charges that were held against you and stated in the substitute information. So at this point in time, I wish you the best of luck moving forward.
Thank you.
Counsel, thank you. Thank you to everyone. Court stands adjourned.
All rise. Court's adjourned.